Good morning. The quest for true religious freedom is one of humanity's greatest and most enduring dreams. Indeed, America's forebears fled the tyrannies of religious oppression abroad in the longing hope that America would be the place where they would find that freedom yearned for in every human heart to live according to the convictions of their faith. Our founding fathers recognized and protected this foundational human right by enshrining it forever in the very first amendment to the United States Constitution. It states very simply and clearly that, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those noble, straightforward words, because of their enormous meaning and implication, have often been the target of distortion and attack. In 1990, the Supreme Court handed down the Employment Division versus Smith decision. It set the bar so low in allowing for the government's infringing on religious freedom that in many cases, individuals could not successfully challenge overreaching laws that contradicted their faith. The Smith decision was widely regarded as one of the most radical departures from this long-settled constitutional doctrine in American history. In response to the Smith decision, with incredibly broad bipartisan support, Congress passed the Religious Freedom Restoration Act in 1993. That law restored the pre-Smith compelling interest standard and, along with it, religious liberty in America. And in 2000, in direct response to another Supreme Court decision that threatened religious liberty, Congress passed the Religious Land Use and Institutionalized Persons Act, which prohibits the application of neutral and generally applicable laws in ways that substantially burden religion related to zoning, landmarking, and prisons. In his written testimony before the Senate Judiciary Committee on September 18, 1992, Professor Douglas Laycock stated, quote, there is a simple reason why formally neutral laws sometimes lead to religious persecution. Because once government demands that religious minorities conform their behavior to secular standards, there is no logical stopping point. Sometimes the government will back off and create an exemption, but often the bureaucracy will grind forward and persecution will be the result, unquote. These critical statutes exist today because a broad group of lawmakers, organizations, and Americans from both sides of the aisle believe that religious freedom was and is far more vital than that afforded by those profoundly flawed Supreme Court decisions. Support for religious freedom remains one of the very strongest commitments of the American people. According to a December 2012 Gallup poll, nearly 70% of American adults are very religious or moderately religious, based on self-reports of the importance of religion in their daily lives and attendance at religious services. Despite its critical importance to our republic and a clear message from Congress and the American people, this current administration's attitude toward religious freedom is nothing short of alarming. The Obama administration has consistently failed to recognize that religious liberty involves much more than the freedom to believe in any religion or none at all. Rather, that religious liberty is exercised both in private and in public, informing all areas of an individual's life. Religion in the United States has never been forcibly confined to one's church or one's home. In spite of the Constitution's clear provisions for the accommodation of religion, this administration has repeatedly failed to create and honor needed religious exemptions from otherwise neutral laws. In the last 3 years, the United States Supreme Court has ruled in favor of religious plaintiffs and against this administration 5 times. Indeed, 3 of those 5 cases have been unanimous. This is stunning evidence of the Obama administration's failure to honor religious freedom in America. My friends, the central phrase of America's Declaration of Independence is itself a statement of religious conviction. It states clearly that we are all created, and that's what makes us equal. And further, that each of us is endowed by our Creator with the unalienable rights of life, liberty, and the pursuit of happiness. It is so unfortunate that we must repeatedly remind the Obama administration that religious freedom is the very cornerstone of all other freedoms, and that if it is lost, all other freedoms will ultimately be lost with it. Now, I look forward to today's examination of the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act. And I would like to thank our witnesses for being here, and I will now yield to the distinguished ranking member of the full committee for an opening statement.
Thank you, Chairman. Members of the committee, religious freedom, of course, was one of the core principles upon which our nation was founded. This freedom was important enough that protections against unwarranted government intrusion into religious practice was enshrined in the First Amendment to our Constitution. And that's also why, after the Supreme Court in Employment Division versus Smith eliminated the compelling interest test for scrutinizing free exercise clause claims, a bipartisan coalition helped to shepherd the Religious Freedom Restoration Act of 1993 into law to restore those earlier protections. The act has successfully helped to protect religious liberty over the last generation. Yet recent developments have been troubling for those of us who believe that exemptions from generally applicable laws shouldn't be used to undermine women's health or the guarantee of equal treatment under the law. Unfortunately, congressional intent and undermine the Act's purpose in Burwell versus Hobby Lobby. In that decision, the court held that for-profit corporations were entitled to an exemption under the Religious Freedom Restoration Act from the Affordable Care Act's contraception mandate because of the corporate owner's religious objection to the mandate. To reach that holding, the court had to conclude that the precedents governing the Free Exercise Clause prior to Smith no longer governed interpretations of the Religious Freedom Restoration Act. That conclusion, to me, is contrary to what Congress intended when it passed the Act. Indeed, the statute itself unambiguously made clear that its purpose was to restore the compelling interest test that applied to governmental burdens on the free exercise of religion prior to Smith. Pre-Smith law was clear that commercial enterprises were not entitled to religious exemptions under the Free Exercise Clause. Also, as Justice Ginsburg noted in her strong dissent, no constitutional tradition nor any prior decision interpreting this act allowed religious exemptions when such an accommodation harmed third parties. Yet that's exactly what happened in Hobby Lobby when the court denied contraceptive coverage to the company's women employees and shifted the costs of Hobby Lobby's religious accommodation onto those women. A particularly troubling implication of the court's broad and unsupported interpretation of the Religious Freedom Restoration Act is that for-profit commercial entities can now seek exemptions from other generally applicable laws, including anti-discrimination laws. This clear threat to anti-discrimination laws could include efforts by businesses to exempt themselves under state versions of the Religious Freedom Restoration Act from state and local laws prohibiting discrimination on the basis of sexual orientation or gender. It could also manifest itself in efforts by for-profit businesses to exempt themselves from any federal efforts to combat discrimination against members of the lesbian, gay, bisexual, and transgender communities, such as President Obama's executive order prohibiting discrimination against such individuals who are employees of federal contractors. And notwithstanding the assurances of the court's Hobby Lobby majority, it's entirely possible that a business claiming a sincerely held religious belief, for example, in white supremacy, could justify exemptions from federal civil rights laws. At the very least, we in Congress must examine how the Religious Freedom Restoration Act can be amended to address the very problematic reasoning of the Hobby Lobby decision. While there's broad bipartisan support for the Religious Freedom Restoration Act and for strong protection of religious liberty, we have to acknowledge that we live in a pluralistic and religiously diverse society. The act was meant to protect all, not to favor some at others' expense. And so at a minimum, we here should amend the act to address third-party harm, to make clear that pre-Smith free exercise clause precedents apply and limit the Act's interpretation. Thank you, Mr. Chairman. I yield back the balance of my time.
And I thank the gentleman, and I now yield to the chairman of the full committee, Mr. Goodlatte from Virginia.
Well, thank you, Mr. Chairman. In 1777, Thomas Jefferson drafted a bill for establishing religious freedom. Introduced in the Virginia General Assembly in 1779, it was enacted into law on January 16, 1786, as the Virginia Statute for Religious Freedom. Last month, we honored the Virginia Statute for Religious Freedom's 229th anniversary. This Virginia law remains relevant today. In addition to being a model for the Free Exercise Clause of the First Amendment, its language continues to provide wisdom. The statute, for example, states in part, "The opinions of men are not the object of civil government, nor under its jurisdiction." This morning, the Subcommittee on the Constitution and Civil Justice will examine the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act. These two laws are vitally important means of protecting religious liberty in the United States and individuals' opinions from an interceding government. The Religious Freedom Restoration Act prohibits the federal government from substantially burdening a person's exercise of religion, even if the burden results from a rule of general applicability. The exception is that the government may burden a person's exercise of religion only if it demonstrates that application of the burden to the person, 1, furthers a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. I co-sponsored this legislation when the Religious Freedom Restoration Act passed the House and Senate and was signed by the President in the 103rd Congress, and I was amazed at the incredible bipartisan support the bill generated. Senator Charles Schumer, who was then representing the 9th District of New York in the House and a member of this committee, introduced the bill. By the time the bill passed by a voice vote, it had the support of 170 co-sponsors from both sides of the aisle. A diverse array of organizations formed a bipartisan coalition to support this bill. This coalition included over 50 organizations, including the American Civil Liberties Union, Americans United for the Separation of Church and State, the Homeschool Legal Defense Association, the Traditional Values Coalition, Concerned Women for America, and the Christian Life Commission of the Southern Baptist Convention. It was incredible to see all sides come together for such an important piece of legislation. Reflecting the same language as the Religious Freedom Restoration Act, the Religious Land Use and Institutionalized Persons Act prohibits any government from imposing or implementing a land use regulation in a manner that places a substantial burden on the religious exercise of a person, including a religious assembly or institution, unless the government demonstrates the burden, 1, is in furtherance of a compelling governmental interest, and 2, is the least restrictive means of furthering that compelling governmental interest. It provides a similar religious protection for institutionalized persons, including prisoners. Congress made it clear that the federal government must provide religious accommodations in our laws, and any laws passed that infringe upon religious freedom must be subject to the strictest scrutiny in our courts. And while religious liberty remains threatened, I am nevertheless encouraged by recent Supreme Court decisions in favor of religious plaintiffs. These cases indicate the religious protections passed by Congress are working. While not determining the outcome of any case, these crucial statutes provide individuals with practical and meaningful ways to challenge government infringements on their religious beliefs in court. I want to thank all of our witnesses for coming today, and I look forward to their testimony. Thank you, Mr. Chairman.
And I thank the gentleman, and I now yield to the ranking member of the subcommittee, Mr. Cohen from Tennessee.
Thank you, Mr. Chairman. Today is the first hearing of this particular subcommittee, and I am the ranking member again, and I appreciate that opportunity to serve, and I appreciate serving with Chairman Franks. We've served together as chair and ranking member, and this is a committee that gets some very emotional and issues where people have strong opinions on each side, and yet Mr. Franks has always remained civil and respectful toward our side, despite the fact that his opinions are light years away. The large universe, and we encompass it, but we do it in a good manner, and I appreciate that. The freedom to practice one's religion free from undue governmental influences, and particularly special in American history, and the First Amendment guarantees the right to a freedom of religion along with speech and petition and our First Amendment protections. And Thomas Jefferson, as Mr. Goodlatte mentioned, he's a big fan of Jefferson's, as am I, has on his resting place in Virginia 3 things, that he was the author of the Declaration of Religious Independence or Freedoms. Nothing being president or secretary of state or any of those things. They were mundane because it was values and ideas and education and liberty and freedom that was so important to him. He has on in the Jefferson Memorial, of course he doesn't have this, the descendants have this, one of his particular quotes is that I swear upon the altar of God eternal hostility toward all forms of tyranny over the mind of man. It's important that we understand that as our founding fathers' legacy and that we adhere to it. And we did in passing the restoration of religious freedom here. I was not here at the time. Mr. Goodlatte was, but I was in the Tennessee State Senate, and I passed the Tennessee RFRA law and was proud to do it. And there was that great coalition, as he mentioned here, of ACLU to the Southern Baptist Convention or something associated therewith, and all kind of diverse religious groups and folks about the First Amendment were all for it. And that was wonderful, and it was about really Employment Division versus Smith. And it was to direct reaction to that case that RFRA was passed with this broad bipartisan support, and that we passed it in Tennessee as well. Unfortunately, our Supreme Court, in its corporization of America, which of course has also been part of the work of this Congress, took religious freedom from the ideas that were really held by Jefferson and others about individuals being oppressed by the government and gave it to corporations. And nobody had ever envisioned that, like nobody had envisioned corporations having the right to have free speech in the thousands and hundreds of thousands and millions of dollars to influence legislation and who gets elected and how the laws are made so that the tax rates are appropriate for those who have much so they can have much more and do much more trickle down. So the corporatization of America has taken place, and the courts did it in this case, and that's what happened and broke apart that great bipartisan coalition that we were so proud of in passing RFRA. To be concerned about the Hobby Lobby case, which is part of a whole series of cases with the Supreme Court and legislative actions that nobody would have envisioned, giving corporations rights and worshiping to the altar of the corporate God, does not mean you're against religion. You can still be for religion, and I'm for religion, and I'm for the separation of church and state, and I'm for the First Amendment, and I'm for RFRA as it was envisioned when it was passed, and restore those pre-Smith laws. But the Hobby Lobby decision was aberrant, and that's why I and many other people who have deep thought and felt commitments to religious liberty oppose Hobby Lobby decision. They still believe in RFRA, and they just think RFRA went too long. It was an activist court, activist in the worst way, activist that gave powers to people that we never envisioned, not activists that went far to give minorities opportunity and minorities rights. It went far to give corporations rights. That's the wrong type of activism, in my opinion. But I look forward to this hearing and listening to all the witnesses and working with Mr. Franks as we go forward.
Would the gentleman yield?
Yes, sir.
I thank the gentleman for yielding. I appreciate his admiration of Thomas Jefferson, as I have. I do want to get his tombstone correct, though. He is identified on his tombstone as the author of the Declaration of Independence and the Virginia Statute for Religious Freedom, but he did not have any involvement in the writing of our Constitution. He was our ambassador to France. Instead, the third item is the establishment
University of Virginia.
Of the University of Virginia.
I thought I said
Right.
that. Let's take a vote. How many think I said University of Virginia? Raise your hand. You're right. Vote's over. Thank you, though.
I thank the gentleman.
The man is from Virginia. Let me now introduce our witnesses. Our first witness is Lori Windham, Senior Counsel at the Becket Fund for Religious Freedom, for Religious Liberty. Ms. Windham has represented a variety of religious groups at every level, from the district courts to the Supreme Court. Her work includes the cases under the Free Exercise Clause, Establishment Clause, RFRA, and RLUIPA. We're glad you're here. Our second witness is Gregory Baylor, Senior Counsel with Alliance Defending Freedom. Mr. Baylor litigates cases to protect the rights of religious students, faculty, and staff at public colleges and universities across the nation. Prior to joining Alliance Defending Freedom in 2009, he served as director with the Christian Legal Society Center for Law and Religious Freedom, where he defended religious liberty since 1994. Our third witness, Professor Nelson Tebbe, teaches courses on constitutional law, religious freedom, legal theory, and professional responsibility at Brooklyn Law School. Professor Tebbe is a co-organizer of the annual Law and Religion Roundtable and has previously served as the chair of the Law and Religion section of the Association of American Law Schools. Our fourth and final witness, Craig Parshall, is special counsel to the American Center for Law and Justice. In addition to being a senior law and policy advisor to Washington, D.C. based groups, Mr. Parshall writes and speaks about trends in constitutional issues, culture, religion, and media technology. He previously served as senior vice president and general counsel at National Religious Broadcasters and was the founding director of the John Milton Project for Free Speech. Welcome, sir. Now, each of the witnesses' written statements will be entered into the record in its entirety, and I would ask each witness to summarize his or her testimony within 5 minutes or less. To help you stay within that time, there is a timing light in front of you. The lights will switch from green to yellow, indicating that you have 1 minute to conclude your testimony. When the light turns red, it indicates that the witness's 5 minutes have expired. Before I recognize the witness, it is the tradition of the subcommittee that they be sworn. So if you'd please stand to be sworn. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? You may be seated. Let the record reflect that the witnesses answered in the affirmative. I now recognize that our first witness. I now recognize our first witness, Ms. Windham. And Ms. Windham, if you want to make sure we turn on that microphone before you start. Yes, ma'am.
Thank you, Chairman Franks, Vice Chairman DeSantis, and other distinguished members of the subcommittee. Good morning. Thank you for the invitation and opportunity to testify on the importance of the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act. I represent the Becket Fund for Religious Liberty, where I serve as senior counsel. The Becket Fund is a nonprofit, public interest law firm dedicated to protecting the free expression of all religious traditions. For over 20 years, it has defended clients of all faiths, including Buddhists, Christians, Jews, Hindus, Muslims, Native Americans, Sikhs, and other faith groups. Its recent cases include 3 major Supreme Court victories: a unanimous ruling in a RLUIPA case, Holt v. Hobbs, the RFRA case of Burwell v. Hobby Lobby, and another unanimous ruling in Hosanna Tabor v. EEOC. Today, I'd like to highlight the positive impacts of RFRA and RLUIPA for protecting the rights of Americans of all faiths, well-known and little-known, large and small. One example. According to documents released by the Department of the Interior, the department had an operation called Operation Powwow. Under Operation Powwow, the department sent an undercover federal agent to covertly enter a sacred Native American religious ceremony. While there, he questioned the participants, observed the ceremony, refused to leave after being asked to do so. The reason for this, the department was looking to see if the Native Americans in their religious ceremony were using permitted or non-permitted eagle feathers. The Beckett Fund now represents Robert Soto, a renowned feather dancer and ordained religious leader in the Lipan Apache tribe, a tribe that has used eagle feathers as sacred emblems for centuries. Federal law grants eagle feather permits to museums, scientists, zoos, farmers, and other interests. It even allows wind farms to kill eagles. The federal government grants permits for some religious uses, but only if the person is a member of a federally recognized tribe. Mr. Soto's tribe is recognized by historians, sociologists in the state of Texas, but not by the federal government. He is not even allowed to use loose eagle feathers picked up off the ground. Applying RFRA and Hobby Lobby precedent, the Fifth Circuit ruled against Operation Powwow and for Mr. Soto. Mr. Soto is currently continuing his case in federal. When RFRA was passed in 1993, the bill was supported by one of the broadest coalitions in recent political history, with 66 religious and civil liberties groups, including Christians, Jews, Muslims, Sikhs, humanists, and secular civil liberties organizations. RFRA passed with unanimous consent. In his signing statement, President Clinton noted that RLUIPA once again demonstrates that people of all political bents and faiths can work together for a common purpose that benefits all Americans. RLUIPA has provided critical protections for religious exercise. The Supreme Court's recent decision in Holt v. Hobbs, another Beckett Fund case, is an excellent example. There, the Supreme Court used RLUIPA to protect a Muslim prison inmate who sought to grow a religiously mandated half-inch beard. The court recognized that government bureaucrats cannot use arbitrary double standards, granting secular exemptions but not similar religious exemptions. The unanimous Supreme Court explained that RLUIPA affords prison officials ample ability to maintain security. At the same time, RLUIPA requires government officials to scrutinize the asserted harm of granting specific exemptions to particular religious claimants. This is consistent with the statement made by RLUIPA's sponsors, Senators Hatch and Kennedy, who emphasized that inadequately formulated prison regulations and policies grounded on mere speculation, exaggerated fears, or post hoc rationalizations will not suffice to meet the Act's requirements. RLUIPA's land use provisions have allowed houses of worship across the nation to escape discriminatory or substantially burdensome land use restrictions. RLUIPA protected a Muslim congregation in New Jersey after the city labeled the proposed mosque a public nuisance and tried to seize its land. One of the earliest RLUIPA victories was for a Christian church in California when the city attempted to seize its land and build a Costco in its place. RLUIPA also protected a Sikh temple when a local government repeatedly gave contradictory reasons for denying its land use applications. Protection for religious freedom, even when religious practices conflict with otherwise applicable law, is an important part of our nation's histories. We applaud Congress's commitment to the principle that religious freedom is fundamental to human freedom and human dignity. I thank you for your time, and I look forward to answering your questions.
Well, thank you, Ms. Windham. And now I would recognize our second witness, Mr. Baylor. And, sir, please turn on your microphone. You got it.
Thank you. My name is Gregory Baylor, and I serve as Senior Counsel with Alliance Defending Freedom, a nonprofit legal organization that advocates for religious liberty, the sanctity of life, marriage, and the family through strategy, funding, training, and litigation. I appreciate very much the opportunity to testify today regarding the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act. I will focus my testimony on RFRA. In response to a damaging and unexpected Supreme Court decision, Congress restored robust legal protection for religious exercise when it enacted the Religious Freedom Restoration Act in 1993. The coalition supporting RFRA and the foundational principles underlying it was remarkably broad and diverse. Over 20 years later, support for those principles and perhaps for RFRA itself, has notably waned in some quarters. Given this unfortunate development, I believe that a look back at RFRA's enactment and the circumstances surrounding it is warranted. Beginning in 1963, the United States Supreme Court held that government burdens on religious exercise violate the First Amendment's free exercise clause unless those burdens are justified by interests of the highest order. Under this approach, the court protected, for example, the rights of a Seventh-day Adventist to decline work on her Sabbath, and it protected the rights of old order Amish families to make religiously based decisions about the schooling of their children. In each case, the court understood that most government burdens on religious exercise come from facially neutral and generally applicable laws, ones that do not single out religion for especially disfavored treatment. The court acknowledged also that although important government interests were behind the laws in questions in these cases, the state failed to prove that exempting these claimants would unacceptably endanger what the court called paramount interests. The court also indicated that government could use other, less restrictive means to pursue its stated goals. The Supreme Court, of course, unexpectedly abandoned this approach to free exercise in 1990 in Employment Division versus Smith, as has been said. The court concluded that facially neutral laws of general applicability burdening religious exercise generally require no special justifications to satisfy free exercise clause scrutiny. A large number of religious and civil rights organizations promptly formed the Coalition for the Free Exercise of Religion to urge Congress to restore strong legal protections for religious liberty. The 68-member, or 66, or 54, I've heard different numbers, member coalition included the Baptist Joint Committee for Religious Liberty, the American Jewish Congress, Americans United for Separation of Church and State, Christian Legal Society, the American Civil Liberties Union, Agudath Israel of America, and the National Association of Evangelicals. The coalition drafted and advocated for legislation designed to restore strict scrutiny to free exercise cases. Large numbers of congressmen and senators from both sides of the aisle co-sponsored RFRA. Lawmakers and advocates for the bill emphasized a number of key themes. First, they observed that pervasive governmental regulation adversely affects adherents of all faiths, large or small. Second, they stressed that RFRA merely set forth the relevant test that judges and other government officials should apply when examining claims of free exercising. RFRA didn't dictate the results in particular cases. Third, and relatedly, and I think this goes to some of the comments that have already been made, Congress and RFRA's diverse supporters were well aware that the statute's protections might be relevant in cases involving emotionally charged so-called culture war issues. Congress subsequently voted overwhelmingly to enact RFRA. It passed the Senate, as has been said, by a vote of 97-3, and it passed the House by unanimous voice vote. Now, recounting this history, I hope, will help serve as a corrective to the current impulse to doubt the wisdom of that Congress and of the very broad spectrum of individuals and organizations who labored to restore adequate legal protection of religious exercise. That impulse is driven in no small part by the Supreme Court's relatively recent decision in Burwell versus Hobby Lobby stores. In that case, of course, the court held that the federal government violated RFRA by threatening devices in their employee health plans. Unhappiness with the outcome of that case has contributed to a growing skepticism, even hostility, towards RFRA and its underlying principles. Indeed, bills that would have partially repealed RFRA were introduced last summer in the wake of the Hobby Lobby decision. Thankfully, RFRA survived. I urge Congress to resist any further efforts to undermine the Religious Freedom Restoration Act, indispensable protection of our first freedom. Thank you again for the opportunity to testify. I look forward to addressing any questions members of the subcommittee may have.
Thank you, Mr. Baylor. And I would now recognize our third witness, Mr. Tebbe. Mr. Tebbe, please turn your microphone on. Yes.
And distinguished members of the subcommittee, thank you for the opportunity for allowing me to testify on these important questions of religious freedom and equality law. It's an honor to be here, and I look forward to answering your questions. At least since the Supreme Court's recent decisions in Hobby Lobby and Holt v. Hobbs, Debate has been intensifying concerning the two statutes that we are discussing today, the Religious Freedom Restoration Act, or RFRA, and the Religious Land Use and Institutionalized Persons Act, or RLUIPA. In my testimony, I would like to highlight one problem with how our RFRA has been applied. Namely, the Hobby Lobby court shifted the cost of accommodating the employer's religious beliefs onto the employees who may not share those beliefs. That violated a core principle of constitutional law. While ordinarily the costs of accommodating religious citizens are borne by the government or by the public, here those costs were shifted onto the shoulders of other private citizens. Protecting religious freedom is critically important, but it cannot come at the cost of meaningful harm to identifiable third parties. Not only should doing that be avoided as a policy matter, but it also violates the religion clauses of the Constitution. There are at least three ways that Congress could address this problem. First, it could amend RFRA and RLUIPA to make them inapplicable when accommodating religious actors shifts meaningful harm to identifiable private citizens. Second, it could amend the statutes to make them inapplicable to commercial actors, which tend to have significant impact on individuals and on the public. Third, Congress could clarify that it did not intend RFRA and RLUIPA to break completely with judicial precedent under the Free Exercise Clause, case law that embodies the constitutional principle I have been describing. Each of these changes would improve the statutes by ensuring that their application conforms with constitutional principle against shifting costs of religious freedom for some private citizens onto the shoulders of other private citizens. In its Establishment Clause cases, the court has invalidated laws that accommodate religious people by shifting costs to others. For example, the court invalidated a Connecticut statute that required all employers to allow employees who observe a Sabbath to take that holiday off. The court held that Connecticut law, quote, contravenes a fundamental principle of the religion clauses, namely that the First Amendment gives no one the right to insist that in pursuit of their own interests, others must conform their conduct to his own religious necessities. In its free exercise cases, similarly, the court has denied relief that would mean harming other private citizens. For example, the court refused to grant an exemption to an Amish employer who is theologically opposed to paying Social Security taxes on behalf of his employees. The court held that granting the exemption would impose an unacceptable cost on the third-party employees. So this legal rule is grounded both in the Establishment Clause and in the Free Exercise Clause, and it's properly part of RFRA and RLUIPA. The principal difficulty with the court's landmark decision in Hobby Lobby is that it did not do enough to protect the company's 13,000 employees and their dependents. Doctrinally, the court reaffirmed the principle I have been describing, but nothing in the decision made its ruling contingent on the employees not being harmed. And in fact, those employees are being harmed right now as we hold this hearing. Although the Obama administration is working on implementing the solution that the court suggested in its opinion, that solution has not yet been put in place. Not only employees at Hobby Lobby itself, but the employees at other companies affected by the decision are therefore currently without contraception coverage. These thousands of people have suffered harm that may well be irreparable, including unwanted pregnancies and other health problems that medical experts sought to address in the regulation. Importantly, not every accommodation of religion imposes harm on third parties. Therefore, this limitation will not frustrate religious freedom writ large. A good example is the court's recent decision in Holt v. Hobbs, which I applaud. There, a unanimous court held that RLUIPA required a prison to accommodate an inmate who wished to grow a short beard for religious reasons. Allowing him to do that, despite the prison's grooming policies, shifted no security risks to other fellow inmates. Justice Ginsburg, joined by Justice Sotomayor, wrote separately in Holt to emphasize both that third parties were harmed in the Hobby Lobby decision and that no one would be harmed by the decision in Holt v. Hobbs. As I mentioned, there are at least three ways that Congress could address this problem. The most direct way would be the one that Representative Conyers suggested, to amend RFRA and RLUIPA to clarify that religion accommodations are not available, where extending them would shift meaningful harm to identifiable third parties. RFRA itself is in need of a restoration. This amendment would return its meaning to something that can claim much wider public and bipartisan support than the interpretation that the Supreme Court has given it in Hobby Lobby. Thanks very much for your time.
And thank you, Mr. Tebbe. And I would now recognize our fourth and final witness, Mr. Parshall.
Thank you, Mr. Chairman, and Ranking Member, Mr. Cohn, and distinguished members of the subcommittee. On behalf of the American Center for Law and Justice, thank you for allowing me to address this very important subject of religious freedom under the Religious Freedom Restoration Act, RFRA. Like my colleague, I will focus specifically on RFRA in my testimony. I make three primary points. First of all, the language of RFRA must not be diminished. If anything, it ought to be expanded to apply to other situations, some of which I have mentioned in my written testimony. I believe with all due respect that all three of the suggestions of Professor Tebbe to amend RFRA would not only diminish but probably substantially undermine the religious liberty rights recognized by RFRA. I'd be glad to address those and any questions that you've got. Second of all, the success of RFRA itself is proven in a number of different ways. First of all, by the cases that have been mentioned by my colleagues at the dais today, but also, of course, by the Hobby Lobby decision by the Supreme Court. But the necessity of RFRA is proven by the Olympian, near impossible legal hurdle that a person has to pass in order to vindicate their religious rights without RFRA ever since the Smith decision of the Supreme Court. And I just mentioned one case to prove my point about how high that hurdle would be but for RFRA. The case was LeBlanc-Sternberg versus Fletcher, a Second Circuit Court of Appeals decision. Now, while RFRA was being debated in Congress, the village in New York State was being formed, and a zoning code was being created, the evidence showed, for the specific purpose of keeping Orthodox Jewish citizens out of that area. Despite that, the U.S. District Court entered a judgment as a matter of law against the Orthodox Jewish plaintiffs. I was retained to argue the appeal in the Second Circuit Court of Appeals. We were fortunate to get that decision reversed, and the religious rights of those Orthodox Jewish citizens were vindicated. But it was decided on a free exercise claim, not RFRA, because RFRA was not applied in that case. But the only reason that we prevailed is because the village officials made the mistake tactically of having a flood tide of anti-Semitic evidence in the record and then corroborated by the way in which they gerrymandered their zoning code to make sure that Jewish citizens could not have in-home synagogue worship. But that kind of a situation in individual specific targeting of religious groups is very, very rare. Invidious anti-religious discrimination is usually much more covert than that. And without RFRA, religious rights in those situations would have absolutely no method of redress since the Smith case. And there are cases like the Holt case, the prison beard case, where there is no evidence that there was intentional hostility against religious belief, more like a thoughtless, bureaucratic decision-making that simply failed to understand the high value of religious freedom. And that brings me to my third point. RFRA, under the rubric of the statute, as correctly interpreted by the Supreme Court, simply says this: if a federal regulation, statute, or action impinges or substantially burdens the sincerely held religious beliefs of individuals, then the burden-shifting interest that must overcome that religious burden on the individuals, and then number two, that there are no lesser burdensome alternatives that are available. Now, why is that burden shifting appropriate? It's appropriate only if you take a high view of religious liberty. If you take a low view, then you will shift, as Professor Tebbe has suggested, you'll shift the burden on the religious person to defend themselves. And I don't think that's what the founders intended, and certainly that's not what RFRA was all about. I pointed out in my written testimony the research data that shows how nations globally around the world that have a high value placed on religious liberty have flourished not only in terms of their economies, but in terms of innovation. I've also cited some of the clear data that indicates that religious America supports an entire private sphere of charitable giving that benefits local communities as a result of the religious liberty climate thus far we have allowed to flourish. But then that should not come as any surprise. Our founders knew how preeminent religious freedom was and ought to be. They, in effect, have given us a sacred trust to protect it. Now the question is, will we honor that trust? Thank you.
Well, thank you, Mr. Parshall, and thank you all for your testimony. We will now proceed under the 5-minute rule with questions, and I would begin by recognizing myself for 5 minutes. Mr. Baylor, some have portrayed religious liberty recently as a conservative issue. And this was certainly the case after the Supreme Court's decision in Hobby Lobby, and much of the written testimony here conversely focuses on the bipartisan effort that passed RFRA. And so I'm wondering what, if anything, has changed. I mean, isn't religious liberty a principle that every American should advocate for? What is the reason for the shift since the Hobby Lobby case?
And I want to acknowledge Professor Marty Lederman, who started to raise that argument, that Hobby Lobby could simply get out of the business if it didn't want to be burdened of providing health insurance at all. Unfortunately, that argument was raised late in the litigation, and there was not a record on how much it would actually cost. So whether that
well, let's just assume that the tax penalty for not providing insurance is substantially cheaper, and obviously Hobby Lobby would be in a position where they wouldn't be complicit in something that violates their conscience. I think it's questionable whether the employees, I think they would have been a lot worse off under that situation. Let me ask you this, though. I'm trying to figure out kind of where the boundaries are here. In terms of how you understand religious liberty, could Congress enact a statute to require churches, like a Catholic parish, to pay for late-term abortions for its employees?
I think that would be a difficult question. I'm not prepared to answer it right now.
But I mean, if under the analysis I think that you're proposing, if that parish were to go and ask for, hey, RFRA, this is a burden on my faith, not least restrictive means, under your analysis, those employees who happen to work for that parish would be worse off because they would not be getting a regulatory benefit, or maybe even Congress would do a statutory benefit. And so wouldn't you have to then say that regulation would have to be imposed on the church?
I see where you're going with this. No. And I believe
why?
The reason is because churches and their relationships with their employees are a special case, and the Supreme Court has recognized.
Okay, what about the Catholic Charities? So this is a big organization. It's not a church. It's based on Catholic principles. Would that mandate apply to Catholic Charities? Would they have to fund late-term abortion coverage for their employees?
I'm reluctant to speak on that question because I haven't thought it through carefully enough. But I do think that Catholic Charities would be required by general laws, for example, to provide adoption services to all couples in just.
Well, that's a difference. So what do you think, Mr. Baylor? I mean, in this situation, under that analysis, well, let's even go further, more into the commercial realm. EWTN, Catholic Station, it's commercial, but clearly they have a religious mission that's core. Would that analysis mean that EWTN would have to provide the late-term abortion coverage, which is obviously something that the people who are participating, running that organization, very much would disagree with?
I think it does, and that's really disturbing about some of these arguments that are being made about Hobby Lobby. Is, you know, we tend to think it's about contraceptive, but actually the objection that was made by Hobby Lobby and by Conestoga and by many of the over 300 plaintiffs that have challenged the mandate is that they don't want to facilitate access to abortion. And this hypothetical that you've spun out is not a hypothetical. It's a reality. The District of Columbia now has adopted a law that will require all employers, including the Catholic Archdiocese, including Catholic University, including Alliance Defending Freedom, to pay for all abortions elective. California has done the same thing. So we need protection from
Let me, because my time's about to expire, there's sometimes distinctions drawn between a corporate actor or a commercial actor versus a non. I mean, I think if you had a sole proprietor who was an Orthodox, running an Orthodox Jewish deli, there would be religious protections for that sole proprietor. I mean, do people dispute that? And if they don't, then simply the fact that he decides to incorporate his business, he would essentially be forfeiting his right to run his business as a I'm trying to figure out where this would go. So can you speak to that issue?
Well, there was a lot of difficult line drawing that folks on the other side of the Hobby Lobby case were trying to engage in during that litigation. And it was pointed out that corporations, I think everyone agrees that at least some corporations have religious liberty. Many churches are incorporated. The Christian school that my daughters go to is incorporated. So you can't say that all corporations don't have religious liberty. And then you have this prospect, as you talked about, as sole proprietorships. And is it really the case that we're going to say that someone who incorporates or has a sole proprietorship as a kosher deli can be forced by the government to do things that violate their religious convictions? The lines just don't hold up. We should keep it as it is. There was an amicus brief in Hobby Lobby that explained that when RLUIPA, the predecessor statute, was considered, Congress understood that RFRA protected commercial entities. They tried to change that and failed.
Thank you. My time's expired.
And I thank the gentleman, and I now recognize Mr. Nadler from New York for 5 minutes.
I thank the chairman I want to go into a little of the history here, first of all. I was one of the leaders in the fight for RFRA back in 1993, and along with former Congressman, now Florida Supreme Court Justice Charles Kennedy, I was the principal author, along with Charles, of RLUIPA. And the congressional intent at that time, and we did pass it by UC on the floor with only Charles and I being on the floor at the time, as the last act before we adjourned in 2000. The U.S. Supreme Court's ruling in Hobby Lobby essentially punched a hole in the Constitution, in my opinion. It took the principle of religious liberty enshrined in our First Amendment and in RFRA and RLUIPA and turned it on its head. The Religious Freedom Restoration Act was intended to be used as a shield, not a sword. It was designed to protect individuals' ability to exercise their religion. It was not intended to allow any of us to impose our religious beliefs on someone else or to use our religion to harm other people. And I think Mr. Tebbe's distinction between who pays the price, the government or a third-party individual, is exactly apropos. When we passed RFRA in 1993, it was not intended to excuse for-profit businesses from complying with our laws. Religious belief was not understood to excuse restaurants or hotels from following our civil rights laws enacted in the 1960s, or an Amish employer from having to pay into Social Security system in the 1980s. I think Ms. Windham mentioned that case. No matter how sincerely held a religious belief, employers should not be allowed to use their beliefs as a reason to refuse to hire people of the wrong, in quotes, race or religion, or to deny employees access to critical preventive health care services required to be provided by law. Now, let me ask you a couple of questions here. By the way, let me mention that all the cases mentioned by Ms. Windham as our RLUIPA cases, the prison beard case, the eagle feather case, the land use cases that were mentioned, all of them, I certainly agree with the outcome, and all of them were well within the purpose. They were exactly why we passed RFRA and why we passed our RLUIPA. The Hobby Lobby case, which is the first case that imposes a burden on third parties, is the exception. Not the exception, it's an extension of the law, because we never intended that third parties should bear the burdens. Now, Mr. Tebbe made that distinction. Let me ask you this. How would you distinguish? We generally provide exemptions in the law. We say that a church, you can't discriminate on religion in hiring, for example. But if you're a church, you can discriminate in hiring as long as the person has to do with the ministry. In other words, you can say we insist on Catholics to be priests. You can't say we insist on Catholics to be the janitor. Where does that end?
I think it ends at the church walls. That is, in the Amos case, the United States Supreme Court addressed that question and that very exemption that you're mentioning to Title VII that allows religious employers, churches in particular, to discriminate in employment in favor of co-religionists. Right? It allows a church to hire only people of the same faith for all positions within the church. As applied in that case, it did impose a harm on a third party, namely the janitor, right, who was not of the same faith as the church. But that's a very special situation. You know, the Supreme Court has recognized, and I think a lot of people have, that churches have special ability.
And the statute recognizes that. If the statute did not recognize that, would that be a constitutional requirement?
Well, there's debate about that. I'm not sure I'd want to take a position on it here, but the statute requires it, and the Supreme Court has acknowledged it in the Hosanna-Tabor case, I think rightly, although maybe that case goes a little bit further than it should.
Let me ask you a different question.
Yeah.
We would certainly say that the corner bakery, or let's be bigger, the large bakery, could not refuse to hire a black person or a Jewish person or anybody on the basis of race, color, religion, creed, faith, etc. Could they refuse the bakery? Could they refuse to sell a wedding cake to a couple of whose marriage they disapprove? Let's say a gay a same-sex couple. If so, why? If not, how do you distinguish that from? Or if so, how do you distinguish that from the refusal to hire the wrong person?
state and local anti-discrimination laws would prohibit that kind of discrimination, even on the basis of religion, and there would not be a religion exemption. There was recently a New Mexico Supreme Court decision that held as much in a case to do with a wedding photographer that declined to photograph the civil union ceremony of a gay couple. And the Supreme Court of that state said that the anti-discrimination law could be applied against the wedding photographer, and there are cases pending now in different parts of the country concerning bakeries, and they're coming out the same way.
And with the Hobby Lobby doctrine, if Hobby Lobby were applied, would you think that would change that result?
It could be a problem, right? So there are state-level RFRAs. One of the dangers with Hobby Lobby and the way it eviscerated the principle against shifting harms to third parties is that it could be mimicked by state-level religious freedom restoration acts by state courts. And if that started to happen, it didn't happen in New Mexico, but if it starts to happen, that could be a problem for state and local laws that protect LGBT people against discrimination.
That's another problem. My last question, Mr. Baylor. I don't remember if it was you or Ms. Windham or somebody cited a number of the zoning cases designed to exclude Orthodox Jewish institutions from certain areas, and that they were rejected on the basis of RLUIPA quite properly. Maybe it was Mr. Parshall who cited those cases, and Ms. Windham. And those kinds of cases were one of the reasons we passed RLUIPA in advance. And I think the court decisions saying you can't do that were quite proper and correct, and I congratulate any of you sitting here who had anything to do with those cases. Now, Mr. Parshall, several years ago, a developer announced plans to build a Muslim community center named Park 51 in New York City near Ground Zero in my district. The project satisfied all zoning requirements, was legally authorized to move forward with construction, but there was significant backlash to the project, specifically because it was a building to be used by Muslims, and some people said that's a terrible thing. It's you know, given its proximity to Ground Zero, it's terrible because after it was Muslims who destroyed the World Trade Center, and it's bad to have a Muslim mosque or whatever close to it. Although your organization usually argues that zoning and historic landmark laws may not be used to stop the building of religious structures, in that case it filed a lawsuit arguing that zoning and landmark laws should be used to bar the construction of the Muslim Community Center. In fact, you filed a lawsuit to prevent the structure from being built. Now, this is the very scenario that RLUIPA was meant to protect. A building project is being contested simply because of the religious belief of those who would use it. What was unusual in this case is that usually when someone opposes a religious building project, they're not honest enough to admit the reason is that it's religious. They find some other excuse, density or whatever. Right. Here they were very clear about it. We don't want a Muslim...
the gentleman's time has expired here, but go ahead and finish the question and let him answer.
We don't want a Muslim structure nearby. RLUIPA is there to ensure that this minority religious group is not treated differently because of what they believe, etc. But the ACLJ not only refused...
The gentleman's time has expired.
I'm almost finished. I have one more sentence to the question. But actively sought to prevent their use of the property. How is blocking the building of a Muslim community center supporting religious freedom, and why would you think that RLUIPA did not protect the religious group in this case?
Well, first of all, as you know, the court ruled in a way that affirmed ACLJ's legal position that we had argued in that case. Zoning codes, and I've done zoning work, I'm not a specialist in it, but those of us who do religious liberty work run into these zoning cases quite a bit. Zoning codes and zoning authorities have the right to use a number of criteria that are religion neutral. And in this case, the reason that the court ruled and the reason that ACLJ argued was not because of public outcry. This wasn't a mob effort. This was a reasoned effort in line with the criteria that zoning boards and zoning ordinances and zoning laws can apply. Things like aesthetics and history, legacy. And in this case, we all have to admit that there is a particular history surrounding the 9/11 tragedy in that part of New York City, very much like the landmarking laws that are often, in fact, the Flores case addressed the competing interest between religious liberty and landmarking. So in a sense, I look at this as a landmarking issue and not a targeting of religion issue.
I want to thank all of you today for this very important discussion. You know, I am reminded of, if I can paraphrase and sort of condense a quote from a great statesman some years ago when he said that out of fervent religious and committed faith arises, from bondage sometimes arises great fervent faith. And that faith often leads to great courage. And the courage leads to freedom. And freedom leads to abundance. And abundance leads to apathy. And apathy leads to dependence. And dependence can lead back to bondage. And I think it's a great admonition on the part of all of us that when we are in times of abundance, to make sure we protect our foundational freedoms, none of which is more foundational than the freedom of religion. And I thank all of you. And
Mr. Chair, before you close, I have a statement to enter the record without objection.
Without objection.
And I would like to take the brief time to say I was wrong. Mr. Goodlatte was right. I think he was correcting me on author of the Declaration of Independence. Mr. Goodlatte is a gentleman. He's my friend. He's a scholar. I pre-anticipated his question incorrectly, and I would have been eliminated from a game show. Thank you.
And I thank the gentleman. So without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. Again, I thank all of you, and I thank the members in the audience, and this hearing is adjourned.